In this video, we'll be going over dotloop. I'm not going to show you how to use dotloop primarily. I'm just going to go over the documents that you typically need in dotloop and understanding the contract and the multiple documents that are required for you making a purchase. And we might even get into some listing stuff in this as well. But it's more just going to be understanding different documents. So I'm just going to create a test loop for this. So again, I don't want to get too much into the details of how to use dotloop because you should already have gone through that during orientation. I'm just going to make a test loop. Call this test 2. And then we're just going to assume that this is a buyer package. And again, if it's pre-1978 build, you need the waiver or you need the lead-based paint addendum. So we're just going to say that in this case because that'll go over a little bit more in detail about what we need for a typical transaction. Again, if it's post-1978, disregard the lead-based paint. You can upload a photo here. Again, we're not going to get too far into that. Okay, great. So you can either click or you can view loop. We'll view the loop. And again, you should be familiar with the different required fields. So we know that if it's pre-1978, the lead-based paint form or the lead paint disclosure is required, title disclosure is required, fully executed contract is required, and you would simply drag and drop into that platform as you do have that. And we'll go through these items one by one. But we'll start with the sales contract because for newer agents or for agents in general, this one can be pretty daunting because it's the longest contract that we have. So I won't fill out any of this autofill section. We're just going to go through this contract, as detailed as possible and understand it. So the first page of this contract is known as Opinion 26. This, when you read through this document, which I encourage every agent to read through this. It's been a little while since I've done it, but I'm very familiar with this contract. Opinion 26 is that essentially saying, and definitely read through it to go over all the points, but that that we can't give any legal advice. We're not attorneys, and we're not representing the clients as attorneys as well. Therefore, we cannot give legal advice. So you definitely always want to read through this with your client or have your client read through this because you don't want to get caught giving legal advice to a client. The client says, "Oh, well, they advised me to do this or they advised me to do that," and next thing you know, you're getting in a whole bunch of trouble for the way that you worded something or for what you told your client. So the law requires real estate brokers to give the following information before you sign the contract. It requires us to tell you that you must read all of it before you sign. The purpose is to help you in the purchase or the sale. As a real estate broker, I represent, and then you would check off whether it's the seller, not the buyer, not the seller, both the seller and the buyer, neither the buyer nor the seller. So the person filling out this part is also going to be, filling out the part where it's prepared by. So you will not get any legal advice unless you have your own lawyer. Neither I nor anyone from the title company can give you legal advice to either the buyer or the seller. And again, this reiterates in a few different types of ways. And for New Jersey, at least for Central Jersey, North Jersey, the areas in which our offices are currently located, most people use attorneys. So if somebody's going to be using an attorney, you still want to make them read through this, but you might not have to go over every single point in great detail with them because they're already going to be retaining legal advice. It's just more important that they understand why they should have an attorney, that they will be using an attorney, and that you understand, more importantly, the information that you can and cannot give them. So yes, you will not get any legal advice unless you have a lawyer. The contract is the most important part of the transaction. It determines your rights, risks, and obligations. Signing the contract is a big step. A lawyer would review the contract and help you understand it and to negotiate its terms. The contract becomes final and binding unless your lawyer cancels it within the following 3 business days. Again, you should know at this point that attorney review lasts 3 business days. It can go on longer, but it's really not supposed to. and the attorney is the only one that can cancel the contract once it's signed, if you do have an attorney. So if you do not have a lawyer, you cannot change or cancel the contract unless the other party agrees to it. So neither can the real estate broker nor the title insurance company change the contract. So it becomes a whole mess if you're not dealing with attorneys, which, again, for 95% of my transactions, I have a client that is using an attorney, unless they're buying cash and they want to close within 2 weeks, and they say, I don't care, the current condition of the property. I don't care about anything that comes up during the transaction. I'm fully aware of my rights, and I'm buying this as like an investor or something like that that's seasoned, that knows that the property is going to be ripped down or something like that. Another important service of lawyers to order a survey, title report, and other important reports. So this just details, like, as long as they have this information, it's just further explains what the job of the attorney is to do. Which that's all this page is essentially saying to them. The reports and surveys can cost you a lot of money. The lawyer will also prepare the documents needed to close title and represent you at the closing. A buyer without a lawyer runs special risks. Only a lawyer can advise a buyer about what to do and if problems arise concerning the purchase of this property. Problems may be about the seller's title, the size and shape of the property, and again, this is all stuff that it's like, if it does come up, you're as an agent are more covered, as a result of this as well. So you should be telling your clients, it's not just to cover, it's not just to have somebody represent you in the purchase of the contract, but there's certain things that a lawyer will ask, or certain situations a lawyer has seen, and most of the time when you're dealing with a full-fledged real estate attorney, they've done way more transactions than you have, because they do them for around $1,000 per transaction to have their business going. Some of these attorneys do upwards of 300 to 500 contracts per year. So it's like you're dealing with somebody that's got sheer volume on you, and that has, in that amount of transactions, seen a lot more than you have as well. So that should be a selling point for $1,000 to have somebody represent you legally. I think for this type of transaction is a no-brainer, especially if it's a regular residential transaction where you're just simply buying a home, and especially if you're a first-time home buyer. This is the second page of the contract. This is where the buyer and seller information goes, as well as the property that is going to be purchased, or at least you're attempting to write up the offer to have the property purchased, as well as the terms regarding the purchase price, the deposit, initial deposit, additional deposit, mortgage, and balance of the purchase price. So really, this is one of the hot sheets that most agents, when they're looking through your contract, that of course the agent should be reviewing every single page, but this is one of the first pages somebody scrolls to when they do receive an offer as a listing agent, is they want to see essentially what the terms are. We'll go over this as well. So table of contents, this just lets you know, what you're getting into, and the different points of this contract and transaction, or the different points that will be addressed. So parties and property description is 1, 2 is the purchase price, and it's just, table of contents. So your client, if they say what is all this, you can just take them to the second page and listen, opinion 26 is going to state that you should really have an attorney during this transaction. The second page is the table of contents. If you just want to go through these points with them, that would probably be best if they are hesitant. A lot of these contracts get signed online now, so people take their time with it. They don't feel like you're pressuring them into signing something in person. So realistically, your clients might not have a ton of questions, but it's just very important when they come to you with a question, why is it written like this, or why is this happening? That you really want to say, listen, you're retaining a lawyer, you're retaining an attorney. We need this contract signed in order to submit your offer. You will have the attorney review process where it clearly states on the first page that you can cancel for any reason or no reason at all with an attorney review. So you shouldn't be stuck on I don't like this verbiage of the contract, because the attorney can always change it later on if it's something that can be changed, which most things will get rearranged or changed during attorney review. But like as a realtor, you're really not, trying to get into those types of nuances. So if they're interested in reading the table of contents, they can, prior to going through all of this. Again, they're going to have to sign and initial like throughout this contract, so they shouldn't be missing anything. But this is just like a hot sheet for you as well if they're on the second page asking you like, what is all this? So for the buyer, you put the buyer's name for the property. And again, I'm not going to show you how to do all of that, but this is where your buyer's information goes. This is where you put their address. This is where the seller's information goes. This is for their address. And then below that is the through the property named in this contract at the price and terms stated below the following property address. This is where you put the address of the property that they're making the offer on. The seller could have a different address because they could own multiple properties. They could own investment properties, or you could be buying one of the investment properties and their actual address will appear here. And this, you can find out the seller's address from either asking the homeowner or just knowing intuitively that that's probably their only property. Or what I always end up doing is checking the tax record, looking up the property address and seeing if there's any additional addresses that is under this person's name. So you have the property address, you would fill in like 123 Main Street, municipal tax map of, this is where you put the town. So let's just say it's East Brunswick, New Jersey. So it'd be something like 123 Main Street, East Brunswick, and then Middlesex County. And lot and block number, you can pull that from the MLS. That should be on the MLS sheet. If not, you can go to the tax record and pull the lot and block number. I've showed you how to do that in previous videos, especially the ones going over the tax map. If you don't have that information, definitely go there, watch that video, and then come back to this contract video. Purchase price of the property. When you're negotiating offers, this is where you put the terms of the offer in the initial offer. So yes, you do need this contract filled out for every offer that you end up putting in, whether it's the initial offer or the final offer. Everything has to be signed. This has to be filled out. So total purchase price, that is going to be the initial offer that you're putting down. So if the property's $200,000 and you want to initially offer $190,000, that's where you would put $190,000. Initial deposit. This is like like in good faith, like some realtors will put down like a certain amount. It's becoming less and less like common these days, where for the most part, like most people will put $1,000 for this amount as an initial deposit, and this initial deposit amount gets funded towards the purchase of the property. So it ends up, being held by the buyer's attorney at first, and then once you conclude attorney review, that would get sent over. Other agents will put, 0 for that amount, and they'll put under the additional deposit the full amount that they're putting. For a property around, $200,000, I typically see a combined effort of both the initial deposit and additional deposit to be roughly about $5,000. So if you're putting an initial deposit of $1,000, this additional deposit would be $4,000. And make sure that your client knows the additional deposit is due upon conclusion of attorney review, whereas the initial deposit is due upon signing. So whether or not it gets sent to the buyer's attorney or it gets sent to the seller's attorney first, as soon as you put initial deposit, that is going to be due. That's going to be due. And most agents will take a photocopy, they'll take a copy of the check and send it over with their offer to show that they do have that deposit check. So it doesn't have to be held by the seller, but as soon as they have an accepted offer on it, you should be sending out that check to be held by either the buyer's attorney or the seller's attorney. Make sure that that's very clear amongst the other agent, amongst yourselves, on who is going to be holding that deposit. Because as an agent in our office, we don't hold those deposit checks anymore. Mortgage amount, this is where, when you're writing up an offer, if they're cash, they're not going to have a mortgage amount. So if they're purchasing cash, no mortgage amount. They're purchasing using a loan and they're approved for 20% down. They say, yes, I will be putting 20% down for this property. You know that 80% of this 190 will be put under the mortgage amount. So just doing some quick math. I know I said I wasn't going to do that in depth of this contract and filling it out, but just so you guys know and can see, 80% is 152,000. And that means that 20% down of this 190 amount minus the amount that you've already put towards the deposits, which is 5,000. That means your buyer has to bring $33,000 to the closing table for this particular property at this particular purchase price. And again, if this is your initial offer and the buyer or the seller does not accept this amount, and you end up locking down a price that's anywhere over this 190, like these numbers will change. Your buyer has to initial on the bottom of each page. So for the first page, they sign. For the second through the last page, they always initial at the bottom. And on the very last page, they not just sign, but they also initial. Third page of the contract, the manner of payment. So the initial deposit, this is where you detail where the initial deposit, if there is one. If there is not an initial deposit, you could put not applicable. You could type other and not applicable in here. The nice thing about these contracts is if you leave, any of the dates blank, it gives you like a blanket of like what is, acceptable and like what is like going to be an automatic date that these things have to be sent by. So in this case, like you could check off where the initial check is going to be held, whether it's the buyer's attorney, the participating brokerage firm, title company, other. Most of the time it's going to be the buyer's attorney, and the buyer's attorney will send the check over to the sellers upon conclusion of attorney review. It's usually how things work. Additional deposit to be paid for the buyer will be responsible for the escrow on or before. So if you leave it blank, it's just going to say within 10 business days or 10 calendar days of fully executed or signed contract. That's just supposed to give you enough time to be able to get in and then out of attorney review. One of the things that they could change in attorney review is that the deposit check is due immediately after conclusion. So if attorney review only lasts 3 days, then after that 3-day period, then the additional deposit check is then due. So this just says that, and you can have a specific date that it's sent by, but this part's most likely going to get changed in attorney review. But know that if you leave it blank, then you have 10 calendar days, assuming nothing changes in attorney review, to send the deposit. And you need to be out of attorney review for that to happen, for the most part. So that's why attorneys will change that in the contract. They'll usually say deposit monies will be sent after the closing of attorney review. Escrow. So this part C just goes over who will be holding the escrow check. So in this particular section, it's customary for the listing agent or the seller's attorney to hold the additional deposit check. That's usually what happens in attorney review. So in this section, you would put seller's attorney. If you have a rare situation where the seller's not using an attorney, then the buyer's attorney would hold it. But for the most part, the sellers are going to want their attorney to be holding that deposit. So if you back out for a reason that is in breach of contract, they will attempt to hold their deposit. So that's why it would be held by the seller's attorney. Principal amount. This is just under the section for D, if performance of buyer is contingent upon obtaining a mortgage. If you read through this, these are just the terms of actually like what the mortgage is going to be like. So the principal amount is like the number that we had pre-fillable on the second page for the mortgage. That's the principal mortgage. You would then check off which type of loan it is. It could be VA, it could be FHA, it could be conventional, it could be a 203K loan. It could be like a different type of loan. So you might want to check that off and put other if it is a different type of loan. Or, if it ends up being cash, you don't really have to fill this out, but you can always check other and then write in cash under this section. Term of the mortgage, whatever, if it's a 15-year loan, 20-year loan, 30-year loan, that's where you'd put that. Monthly payments based on whatever year payment schedule. This is the spot for the mortgage commitment letter. So typically for the mortgage commitment letter, if your buyer is filling out all the paperwork correctly and you have enough time, you should be able to get the mortgage commitment letter within 30 days of putting in the offer, 30 days upon conclusion of attorney review. So if it is, if left blank, it just automatically says 30 days for the attorney review period completed. You want to give that time to your client for sure. You want 30 days to be able to get it. If it's a 45-day close. So I just got pulled away from the video, so we might have a little bit of overlap at this point, but I apologize for that. So I believe we were talking about the mortgage amounts and where we're putting for the mortgage commitment. And I was essentially saying that after 30 days of the completed contract, that's when you want to have the mortgage commitment due by, and usually at least 2 weeks prior to the closing or the scheduled closing of the property. So if you're doing a 45-day close, then 30 days is essentially plenty of time. If you're doing 60 days, then anytime after 30 days, but before 2 weeks of the closing will give you enough time to be able to stay on track. So once you have the mortgage commitment letter, you're approximately 2 weeks away from being able to, go through underwriting and actually close on the property. Again, if you leave it blank, it'll just, pre-fill that. Balance of the purchase price. The balance of the purchase price should be paid by the buyer in cash or by a certified cashier's check or a trust account check. So this is the actual place where you put the closing date. It says it down here. It's the closing. So this is the first part of the contract you're going to see with the closing date. This is one of the more important things for you to fill out because, as we were saying, the second page of the contract is definitely one of the key sheets that the listing agent will look at if you submit an offer to them, or if this is an offer coming in on your property. This might be one of the first things you look at too. This is going to actually show the date in which they're looking to close. So whether it's 45 days or 60 days or 90 days, you put that from the date in which you're writing the contract. Sufficient assets, this just, again, you can read through these in a little bit more detail, but just saying that the buyer has, the funds to be able to close all the necessary cash assets, to move forward with the mortgage amount and the loans and whatnot. Accurate disclosure of selling price. That's fine. Accurate disclosure of selling price. Buyer and seller certify that the contract accurately reflects the gross sale price as indicated in Section 2 of this contract. Buyer and seller understand and agree that this information should be disclosed to the Internal Revenue Service and other governmental agencies required by law. Items included in the sale. Now, this type of part of the contract, you're definitely going to want to go over the MLS sheet and see what items are actually included in the sale. Because this next section is where you're going to fill those in or reference the MLS sheet to be able to have that information readily available. It's also a good idea to, reference the MLS sheet, attach it to the contract so that, if the seller's agent or the listing agent changes the MLS sheet at any time, you have the MLS sheet attached as a reference point. So if they say that a washer and dryer is included at the beginning of the sale, and that's what states on the MLS sheet, and you have that referenced in here as as per the MLS number, whatever the MLS number for the property is, and the MLS sheet's attached to the property, and you also have it, well documented that that's what was in agreement, then there should be no confusion. There should be no funny business going on. Like they will be held to including that in the sale. But if you don't include those reference points and then the listing agent changes it at any time, even though that's against the rules and like they're not supposed to be doing that, if you don't have proper documentation that represents that, then you might be held liable, or you're gonna at the very least look bad in front of your client, because that was your job to be able to put what's included and what's excluded and hold them to that. Although, you would hope nobody pulls any funny business. I've seen it done before. Definitely go through the inclusions and exclusions on the MLS. Make sure your client is very aware of what's included and what's excluded, and make sure that it's a part of this contract when writing an offer. Items excluded for sale. It'll say that on the MLS sheet as well. We won't go in under that because I've showed you where to find that. Just if something is excluded, make sure your client knows that and make sure it's referenced here. Dates and time for performance. So it's just saying that, the buyers and the sellers are going to both work together to make sure that these dates are hit, if that is what it is agreed on. So, seller and buyer agree that all dates and times included in the contract are of the essence, meaning if they say the closing's in 60 days, whatever steps the buyers need to take to be able to close on time, they should be taking, and they should be doing it in a timely fashion. Same goes with the sellers. The seller needs to get the C of O or smoke cert, that they're going to do those as soon as possible, or as soon as it makes sense to do it in the transaction, so that that's not a thing that's holding up the closing at any point. Additional documents from lenders or other property owners. If a lender or other property owner requires that an addendum or any other documents be signed for a property it owns in connection with this contract, final execution date, acknowledged date, or a similar language that sets the time period for the completion of the conditions or contingencies, including but not limited to inspections and financing, shall mean that the time that will begin to run for the attorney review period is completed, or if this contract is timely disapproved by the attorneys in the attorney review clause section, then the date from the parties agreed to the terms of the contract. And that's just essentially saying that, all of these dates and whatnot, could change in attorney review, and that they should be, if they are going to be changed, there should be a reference point changed in attorney review, and then that will take precedence. Certificate of occupancy and zoning compliance. Seller makes no representing. So this is actually, a part for the seller to fill out, or it's supposed to be, because under certificate of occupancy and zoning, if left blank, it's 1.5% of the purchase price. To be able to get the certificate of occupancy, one of the documents you need, if the town requires it, in which this property is, to be able to get certified from the township saying, yes, this property is, safe to sell, or this property meets all the requirements, or there's no open permits on this property. Municipal assessments. Again, this is something that the seller really should fill out. Most people fill out for the seller, but I leave it blank for the seller to be able to fill out, or for the listing agent, because municipal assessments, seller represents that either the property has or has no municipal assessments. Again, some people check off has not. That's a section that's for the seller. So if anybody's going to do it, it should be the seller. And if the seller informs the listing agent to check it off for them, I don't believe they're supposed to do that, but at least you didn't check something off you weren't supposed to. Title shall be free and clear of all assessments. That's just saying when they do a title search, that the seller is saying that anything that's attached to that property that they're going to have to take care of prior to closing. Quality and insurability of title as well. At the closing, seller shall deliver a duly executed bargain sale deed, covenant and grantors acts of deed satisfactory, just meaning clear and free title, essentially. Definitely read through this. Definitely understand a little bit better than what I'm saying. But it's just, quality and insurability of the title is, essentially the statement. Shall be good, it shall be marketable, it shall be insurable at regular rates. So there's nothing like funny with the property that will pop up and be a surprise to the purchaser. Near this specific section, this is where you put, whether or not it's a single family home, whether it's a multifamily, like things like that. For most of your transactions, this is going to be a single family or a multifamily. So even if it's a condo or a townhouse and it's only one family that can occupy this property, or the size for one family to occupy the property, you'll put single, whether or not it's condo or townhome. For multifamily, or for like a 2-family, 3-family, 4-family, this is where you put multifamily residence, 2-family residential dwelling, 3-family residential dwelling, 4-family. Anything above 4-family residential dwelling is considered a commercial property, and that will require a different contract. And we're not going over commercial properties. Improvements. Going to the next section, possession, occupancy, and tenancies. So you might have a client that is purchasing a property that is currently being rented. They might be buying it, and if the client is going to be, or if their client's going to be buying the property as an investment or allowing the person renting the property to stay in the property, then the sellers, this is another section for the sellers to essentially fill out, but you can fill it out if they do give you this information. Otherwise, the seller's supposed to fill this section out. So if there are tenants in the property, check off whether or not it's applicable. If you have their name, location, like rent, security deposit, their terms, you fill that out. If you don't, definitely have it addressed in attorney review. It's definitely going to come up in attorney review, but try and fill out this contract to the best of your ability. I would definitely ask for the tenant's name, their rent, security deposit, and the term for that lease at the very least. And again, if there's no tenants, select not applicable, move on. Lead-based paint, we said that this property was built prior to 1978 because that's the type of transaction I'm trying to simulate right now. So we're going ahead and we're just going to click applicable, and it essentially goes over everything that's on the lead-based paint form. So document acknowledgement, lead warning statement, inspection, like what your client has the right to do and what they don't have the right to do. And again, all of this ends up being reiterated on the lead-based paint addendum itself. But it's a part of the contract, and they should then read for it again. When I'm filling this out and my client's asking about this section, I say absolutely read through this. We're going to get to the lead-based paint, the addendum, separate addendum next that will take like precedence over this contract. So if you want more information, like it'll be there. You can also give them the lead-based paint pamphlet that explains everything. But definitely make sure that they know that if it is built prior to 1978. And if it's not, if it's after 1978, then no need to do it. And this just goes over the time period that you have to be able to inspect the property for lead paint, and the time the seller has to respond and remediate it, or if there is an addendum that that the seller needs to sign regarding lead paint, that they will give to you in a timely fashion. Point of entry system. This is for a property with a point of entry system. Also, could mean like a septic tank or something like that. So any point of entry into the property that is like with regards to like sewage and whatnot. There could be other point of entry systems, but that's essentially what you're going to see is like either like a septic system or like a cesspool. And again, if that is the case, check it off. Make sure that they understand what a point of entry system is. Like water treatment, it could be like a well is in addition to that. So like a well and a septic system and cesspool. And then again, right below that, cesspool requirements. If it does have a cesspool, you have to check off whether or not that's applicable. And then there's a few other statements as well pertaining to the cesspool that you have to fill out. Inspection contingency clause. This goes over the rights of your client or the buyer to hold an inspection, like a home inspection, test for radon as well down here. So it just goes into essentially why they would want to check the structural, topographical, environment components of the property, why they would want to test for that, and making sure that they have somebody that's licensed and able to do the inspection within a timely fashion. We'll get down to radon. So they tell they give information pertaining to radon and how it could be potentially harmful, and getting a qualified radon inspector to test for the property if it's especially if it has a basement. If a property has a basement, most of the times the inspector is going to recommend checking for radon gas, because that radon gas is comes through the ground and expelled into the air. So people test for radon even with properties that don't have basements, but usually if it has a basement, it's got a lot higher chance. Or like, since you're breaking open the ground and you're below grade and below ground for most basements, that ends up being like a potential issue. So definitely want to check for that. Below that, we have the infestation damage for wood boring insects, termites, carpenter ants, all of that stuff, and it gives you like a detailed like rights to inspection when you should be holding these inspections. Most of the time you have 10 to 14 days upon conclusion of attorney review to hold inspections for the property for both the wood boring insects, or for all three, radon gas, and a home inspection. And if there's any other structural inspections you want from like a structural engineer, you can add those into this as well. Most people will stick with the inspection from the home inspector, who also then covers the radon and the termites as well. And then you can just read through, and it says if left blank, you have 14 calendar days, and most of the time that'll stay that, or like in attorney review, maybe they'll change it to 10 days, 10 business days or something like that, which is essentially the same thing. Buyer's right to inspections. This is the same thing, just like the time frame in which the property is going to be sold. Buyer acknowledges the property is being sold as is condition. Don't be too scared of a buyer's as is condition. You might want to preface that to your client. If it directly says buyer sale as is, that usually means that the seller is less likely to want to fix things, and that you need to make offers based off of what you can actually see, for the property. So if you're doing an as-is sale, like if you're purchasing like a bank-owned property, or a property where the seller is not willing to do any fixes, it's a good idea to, if your client says like, oh, this is going to need to be fixed, that's going to need to be fixed, anything that you can see with your eyes, you definitely want to have that factored into your offer, and tell your client that's like, hey, listen, it's going to be extremely hard to negotiate with these people, especially since they're not saying that they want to do it. So prior to making an offer on a property that's sold as is, you want to find out how much that surface level work is going to need, and then factor that into your original offer price, because like it's most likely not going to happen. Responsibility to cure. If any physical defects or environmental conditions other than radon or wood-boring insects are reported by a qualified inspector to the seller within the inspection time period, seller shall have 7 business days after the receipt of such reports to notify the buyer in writing that the seller shall correct or cure any of these defects. So it's just like, if they don't correct these defects, like then the contract can be canceled at that point. But the sellers are responsible for curing any of these major defects that are uncovered throughout the process of inspections. And even if they have an inspection themselves, or they find something else out, they have to notify the buyers that they're going to handle that, and notify the buyers that there is something wrong. So if they have any information, they have to let it be known. Flood hazard area, if applicable. This just goes more into flood zones and what the flood areas are, and that you'd want to check to see if the property is located in a flood zone, and what the rules are if that happens. Like if you know about a flood zone prior and the buyer's okay with it, you've already acknowledged it, you're moving forward, you shouldn't have any problems in the future. It's just essentially saying that if you find out the property is in a flood zone without knowledge of it, then you have the right to cancel the contract, or you have the right to find out how much it's going to cost you prior to moving forward within a certain amount of time. And please read the contract and understand that. Qualifications for inspectors, where the term qualified inspector is used in the contract, is intended to refer to persons or businesses that are licensed or certified by the state. So yeah, essentially you can't just have your friend that says that they know something do an inspection for a property. Like, that's not a good idea. Megan's Law. If you're not familiar with Megan's Law, read up about it, because every buyer has the right to be notified about this, and they can look it up on the njsp.org. Notification regarding offsite conditions pursuant to the new Residential Construction Offsite Conditions Disclosure Act. The clerks for the municipalities pursuant to the new residential offsite constructions surrounding offsites. Air safety and zoning, like these things, like read through them and understand them for the air safety and zoning. Like there's such a thing as airspace, being close to an airport, knowing like the safety rules. Like if you know there's heavy air traffic around a property because there's an airport, definitely read through this, definitely know what that means. It's not too common, but it can happen. This is like a list of municipalities and airports that are within them. Bulk sales. So the New Jersey bulk sales law applies to sale of certain residential properties. This is all for the this affects like taxes and whatnot, and like this is for the attorneys to discuss with the clients. But definitely know like the bulk sales, and definitely speak to an attorney if you don't fully understand this. I don't want to go into exactly explaining what this means because I don't want to be held liable personally. But read through this, understand it. If you don't, give us a call. We'll put you in touch with an attorney that'll actually explain that to you. But I don't feel comfortable like going into bulk sales. Like you could look it up on the internet. Definitely refer this one over to your client and say, like, when it comes to bulk sales, I want you to have like the best possible explanation. So if you have further questions, definitely consult the attorney. And that's an excuse you can use. It's not even an excuse. It's just like proper practice for any points of these contracts. Like there's a reason why you have attorney review period. And that's for the attorney to go over all of this information with your client and make sure that they're properly represented. So you can't give legal advice. We already covered that on the first page. So if you don't understand something, or if something is like a bulk sale and might need further explanation, I wouldn't feel comfortable trying to explain it to you guys. So don't feel if you're not comfortable explaining it to your client, refer that one over to the attorney. Notice to buyer concerning insurance. Buyer should obtain appropriate casualty and liability insurance, binder insurance. Like this is all stuff that they should know, that they should be going over. Maintenance and condition of property. Seller agrees to maintain the grounds, buildings, and improvements in good condition. Means like whatever that means, like to a certain standard. They can't just let the property go just because they know somebody else is going to buy it and they don't have to maintain it anymore. Like that doesn't mean that they can just like essentially like let the property like grass grow or like not take like care of a problem like a leak as it happens. They agree to even though they know they're selling their home, that they need to keep it to a certain standard themselves. Risk of loss and damage to the property by fire and otherwise, except ordinary wear and tear is responsibility of seller until the closing. All makes sense, or it should make sense to you. Initial and final walkthroughs. In addition to the inspections set forth otherwise in the contract, seller agrees to permit buyer's duly authorized representative to conduct an initial and final walkthrough inspection of the interior and exterior of the property at any reasonable time before the closing. Seller shall have utilities in service for the inspections. So, when you first went to see the property, right before the closing, I like to do it as quickly or as close to the closing as possible because that'll mitigate for like the chance of something happening in between, like an act of God or like some horrible accident where a tree falls or something like that. Can't predict from those things, but like if a tree falls and like hits the property and that was in between the time that you did your final inspection after the property closed, like that would be very hard to prove that happened during the ownership of the previous seller and onto your client. So like that's why it's like important to do a final walkthrough like not a week before the property closes, but maybe that morning of, if the property's scheduled for closing at or 11 or 12 o'clock, like maybe do it that morning at 8 or 9 o'clock in the morning before your client goes to the bank to get the certified check or cashier's check that they need. You can do it a day before. Again, like you should inform your client of that risk, that it's like if no one's going to be at the property, or if something happens to the property in between you and them being there and the closing, then it becomes like a very tough battle to actually prove that those things happened, like before the closing. Adjustments at closing: seller shall pay for preparation of the deed, realtor transfer fee, discharge fees, if any, and 1/2 of the title company charges for distribution and attendance allowed by the commissioner of insurance, but also just a title insurance premium and others are expenses of and paid for by the buyer. This is just essentially going over the cost, the closing costs, and what's going to be, and part of it, and why some instances are going to be covered by the seller and others by the buyer. Definitely to speak to a mortgage lender and attorney, and also your colleagues, to fully understand what kind of closing costs will appear throughout the transaction. So when your client asks, be like, okay, I put in this offer, what other costs are going to come up? What's like, you have closing costs when it comes to the buyers, like the deed transfer and whatnot, like, or at least part of the deed fees and like closing costs and whatnot. So the sellers pay the realtor commission typically in the state of New Jersey, and then the buyers pay for other closing costs such as like the inspections and their attorney fee, and and the new deed recording and stuff like that. So read through this, fully understand it. If you have any questions, again, give us a call and we'll put you in touch with somebody that's legally obligated or like legally allowed to discuss this information with you. Failure of buyer and seller to close. This is another page where it's just like, if seller fails to close title in the property in accordance with this contract, buyer may commence any legal or equitable action to which a buyer may be entitled. So just essentially saying, like, let's say the seller is making no ability to close on the property, they just string the buyer along. Like, the buyer, might want to sue for damages in that part, and like the brokers, like, everybody can be involved in that if somebody breaches the contract. So that ends up being pretty messy. So again, like, it's just saying that everybody is going to do their best to get to the closing table, and no one is going to pull any funny business. And if it happens, that legal actions can be taken. Consumer information statement acknowledgement. By signing below, you guys should know what the consumer information statement is, and if you don't, we'll go over that. I'll go over the actual consumer information statement in this video when we go over the other documents as well. But this is just another consumer information statement. It essentially says the same thing. It is the same thing as the consumer information statement, but it is just added to this contract as well. You have to get buyers to fill out both. Name of the firm. So if you're writing the offer, this is RE/MAX First. Representatives, this should be you. This should be your name for whoever is filling this out. Are operating this transaction as a seller's agent, buyer's agent, dual agent, transaction broker. Definitely check off whichever applies. If there is another firm, like if your firm or our firm is not representing both sides, there is a listing brokerage, and you would put their company information here and then just who they represent. It's likely it's going to be the seller in this case. And then, like on the MLS, like you pull all the information or ask the sellers or the listing agent for all their information. You want to fill out the listing firm information, their license ID number, the listing agent, their license ID number, address, telephone, agent phone number, fax number, email address, commission due to listing firm. So whatever it says on the MLS, all this information is going there. When you have the information, the MLS access, you should be able to fill out this entire page, including all of your information from the MLS. So just look through that, fill it out completely. It'll look better. It's required anyway. Just fill this fill this contract out as quickly as as full as you can. Equitable lien under New Jersey law. Brokers who bring the parties together in a real estate transaction are entitled to an equitable lien in the amount of the commission. This lien attaches to the property being sold for when the contract of sale is signed off on. So this is just a clause that ensures that the realtors are going to get paid. We're doing this work for the above mentioned commissions, and if those commissions aren't paid, that ends up becoming a lien on the property. So again, know that, understand that. Haven't seen any problems with that, but I know that it has been a problem for other agents in the past. So just know that that's a clause to protect the brokerage and to protect the agents. Disclosure that buyer or seller is a real estate licensee. If that's true, that has to be stated. The listing agent should allow you to know that, or it should have that listed on the MLS, and this should be filled out appropriately. So if the seller is the listing agent, their own agent, or just an agent themselves using another agent, that has to be disclosed. Brokers to receive closing disclosure and other documents. This just ensures that the closing documents, any of these documents are allowed to be given to the brokerage firm so that we have it for our records. We do need that stuff. Professional referrals. Seller and buyer may request names of attorneys, inspectors, engineers, tradespeople, or other professionals from their brokers involved in the transaction. Any names provided by the brokers shall not be deemed to be a recommendation or testimony of competency and the person or person referred. So this is a tricky one. You're going to have clients that ask you all the time for recommendations because you should be buying and selling properties a lot more than they should. So if they don't have their own people are going to, hey, do you have an attorney that you recommend? It's tough. You want to give them at least 3 attorneys, at least 3 attorneys if they ask for recommendations, because you don't want to be pushing favorites or like, oh, I work with this attorney. This attorney's great. And breaking the rules is part of this contract. It's part of the law. If you're saying like, oh, this attorney's better than this attorney, like you're just essentially saying that this attorney's more competent than that one, which is against the rules. Same with inspectors, same with mortgage lenders. You're not supposed to be doing that. So definitely, like if you're working with 2 or 3 attorneys, recommend them. Absolutely. But don't go too far and say like, this attorney's great. I fully co-sign this attorney's ability. It's like you've gone too far at that point. Attorney review clause just goes over. So studied by the attorneys review the contract, counting the time. You count the 3 days. You cannot do Saturdays, Sundays, or legal holidays. A notice for disapproval. The attorneys cancel the contracts at all, like usually, and then they'll rewrite the contracts to be more favorable for both clients. Notices, all notices and how they shall be received, whether it's certified mail, fax, email, recognized overnight courier, electronic documents. Like these are all like notices of what these documents could be conveyed as. Entire agreement, parties liable. The contract contains that the entire agreement of the parties, no representations have been made by any of the parties, the brokers, or its sales persons, except as set forth in the contract. So everybody's the name that's on the contract. Those are the people involved. There's no other people that shouldn't be involved in the transaction, or no surprises anyway. Applicable laws. This contract shall be governed by and construed in accordance with the laws of the state of New Jersey, and lawsuit relating to the contract or underlying transaction shall be venued in the state of New Jersey. Section 42, if you have any addendums, if you have any buyer home sale contingencies, if you have anything like that, those addendums are attached to this contract, and you are supposed to check off the boxes for those things. Additional contractual provisions. Any changes made to the contract or that the buyer or seller wants added to the contract goes here, whether it's a seller's concession, whether it's something that's not on the contract, whether it's like that they want something included in the sale that hasn't been stated by the seller, like let's say the washer and dryer is not included and they wanted the property, but they want the inclusion of the washer and dryer. This is where it would go under. This is where you fight for extra things, or that you include extra things, or say that you have a home to sell. So, one of those quick pages that agents scroll to is going to be this, because they want to know if there are any additional contractual provisions. So second page, third page. Second page has like the actual offer amount. Third page has something like the actual closing date, and then in addition to that, then you have the additional contractual provisions on the last page, and that's going to bring to light any other things. So it's like those are the main things that people scroll to. Of course, you want to read the whole contract. Of course, you do. But those are the hot points, and those are the hot sections. And then below that, assuming you've initialed at the bottom of each page, you also sign this page and initial here as well. We're approaching the limit for 16 minutes for this particular video, so I'm going to make a separate video going over the other documents. But this is the long one. This is the main document in terms of offers, and like this document takes the most amount of time to go over because it is 13 pages. But I will see you guys in the next video to go over the other documents of the transaction that you're going to need to know.